Hey, how are you doing? Hope everyone's doing really good. Just going to be sharing a few different results over the next few days, just showing what's been going on in our GDPR world when we're actually using the GDPR, DPA 2018, as well as the Law of Property Act 1925 and the Law of Property Miscellaneous Provisions Act 1989. As well as the case laws that we've been working with, not the older ones, very famous ones, I suppose you would call them famous in this line, which is the Van Linn versus Pelias construction, but we've been using more along the lines of 2023 as well, where we've got a solid case law from the Chancery Division of the High Court as well. So we use those when we actually challenge. Now, this one I'm going to show you today is a member who's actually challenging or defending, I should say, a claim from one of the debt collectors. Now, this is PRA Group. Now, this is the second win we've actually had very recently. So I'm going to show you this one on its own, and I'm going to do another video, show the other one for the lady from our group. This is a bloke who played them at their own game using the correct legislation, and that's all it is. You know, we don't give legal advice. We just actually show people what the law is. We show them what's on the legislation books. It all comes from the government website. We show them GDPR website, data protection. It all comes down from gov.uk. We show them all of the Law of Property Act that comes down from gov.uk. So, you know, we didn't make it. We didn't invent it. This is what rules the actual debt industry. It all comes under property because all debt is classed as property in UK law. You'll see them all the time, and you know they talk about it themselves. The Law of Property Act 1925, Section 136, and they twist it because they like to use one part of it without reading the other part of it. You know, and it all ties together with the other parts of the Law of Property Act as well. You can't just use the one line, and although they do get away with it a lot, and the reason why they get away with it is because they actually send it through to Northampton, which is not a court, it's just a business centre. And if people don't challenge it, then they just get an immediate, not immediate, but when it gets through the process, they get a CCJ against them because it's just literally a rubber stamping exercise in these offices. No one like of a legal training sees it. It's just done. Boom, stamp, away it goes. If they challenge it correctly, then it goes into the county court, the lower county court. What will happen is you get these debt collectors and they will request, when they put their N1 in and they're filling in the forms, they will request a deputy district judge. So they know they're getting a low down judge who's going to be like overworked, overstressed. They want the cases done and they will be allowed extra discretion, right? Under CPR 27, the judges are allowed discretion. I have been in the courts listening to it, and some of it is shocking and has to be challenged. And but you've got to, you know, go through training and knowledge of yourself. You've got to do it for yourself, train yourself to know how to actually respond to these situations, because there's a certain discretion and they have discretion to allow the hearings to flow because it's a small claims track. You're not allowed any disclosure in CPR like 27, which is the small claims track, which is where they all go for the deputy district judges. So they're not going to have anything like showing you any documents because they don't need to. You can't say, "Oh, I want to see the deed of assignment under CPR 31.6 or CPR 31.14, which is standard disclosure or specific disclosure," because they don't. You're not allowed to ask for that, or you can ask for whatever you want. You're not going to get it. You're not even allowed to say CPR 18, which is kind of like a request for disclosure. You can't use that. And the judges are under their discretion completely just went, boom, no, you're not getting any of that. What they're not allowed to do is they're not allowed to actually abuse the discretion by ignoring like set case laws. And when you talk, but they do regularly. So you've got to have the correct information ready about, you know, what they're allowed under their discretion and not. And hold them to account. They're just a bloke or a woman sitting in the court. You know, they're nobody any better than you are or anything, but you've got to have that knowledge. Okay, so we share the knowledge. You know, we're not like inventing anything. We're just showing you what is in the books, the law books. So their discretion and the CPR rules, which is the court procedure rules, they call it the big white book, and they'll have it on their desk, and they'll flick through it and they'll read from it, and they'll say, well, under CPR 27, blah, 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 I'm allowed to use discretion, and I'm not going to ignore that. I heard a lot going on about that Mazur case, if that's how you pronounce it. I'm not really sure. Mazur. It's not new case, and it doesn't say anything about a new law. It's just saying about having the correct qualifications to litigate, because it's a reserved action. A legal services act. You have to be a qualified lawyer or barrister, solicitor, whatever it is, to actually litigate in court, obviously. So whenever we're there, we're not allowed to speak. We're not allowed to say anything. We can whisper to who's in the court, but we can't go and represent people or do things like that. Not even as a Mackenzie friend. You've got to keep your mouth shut. But the case that I was in, and they used the discretion, and this debt collector's representative says, no, I'm just a layperson. But then the judge, we won that case in Newcastle County Court, and the judge actually struck that out. Well, if you're a layperson, you can't be in here, then that's it, finished. They appealed it, and the judge says, well, the new judge says, I'm going to use my discretion. I was on the floor, but we made a lot of notes, and we know that there is no trail for the deed of assignment on that case. So we're looking forward to actually fighting that again. So that will be very interesting. And literally, because it changes names going through. It's not just like a normal one. This is one of those Clydesdale Bank PLC ones. Very interesting. So if you've ever seen my videos on them, but if you haven't, go and check them out. But anyway, so what I'm going to do, I'm going to share my screen, because I want to show our group. I keep forgetting. Share the screen. So there, I made that full screen. As you can see, I've blanked the name out, but this guy, he's actually sent this message to me on our group, and it's just saying there, it was a win, mate. Struck out. I don't know if you can see that. That clearly. Basically, I'll read it out to you. So it just says, struck out. Judge wasn't having any of their bullshit. His words, not mine. Told me straight after she'd waffled on that it looks like you're going to have an easy afternoon. So there you go. Absolutely great. And come back in. And then what I'll do is I'll actually share the group. And I'm going to put a link in the description. And anyone who wants to come and try out the group can actually have a look. And there's different levels to it now. Depends on what you want. Because we've actually got the car parking app that we've designed. Well, when we were looking at, we went to specialized courses on building these apps for the parking parasites, is what I call them. We have our community side. So it's very similar to what would you call it? Social media, so people can make posts. Then we go into the classrooms, and in the classrooms here, we have the new members information there, and there's the parking parasites, smashing the parking parasites. So our app is in there. Then we have resources on there. We have all different types of forms, legal versus lawful. We have our self-defense program. Then we have our guardians and equity training. That is basically to become a Mackenzie friend, not to become one, but to learn how to be one, so you can help others. We just have a sovereign mastery here, which is more of about your mentality and your spirituality. And we have a mindset, right? The pain of discipline or the pain of regret. Which one do you want? Our crypto classroom with Mike. Then we have our legal chatbot down there, which is a specific one, different to the park and parasites one. We record all our meetings. Then we have our GDPR classroom, our sovereign debt negotiator. This is where we actually can reduce all of the payments that you make if you're already working with a debt collector. So it's similar to an IVA, but without the costs. These are the different classrooms that you can actually have. Let me just stop sharing there and come back in. So there is the group, and obviously that's the results that we're getting. We're going to do other videos as well, showing the results that the group's members are getting when they're challenging these, and they're only using government legislation. That's all it is. We're not coming and doing anything weird or wonderful, and there's no legal advice done whatsoever. All it is we actually show them what is on the government websites. which is the gov.uk, and it shows you the you can download all of the legislation. Then you have to go on to other sites where you can get the case law, and you have to sometimes pay subscriptions, and then you can download the full case law, exactly what the judges said, the lords said, and all of this is your case law and it's got to be high court, and you can learn all about like the Senior Courts Act 1981 from, again, the government website. None of it's made up. We're not giving people any legal advice. We're not telling anyone what to do. We're not inventing anything. We're just showing them what we find on the government websites. What more can you say? Just wanted to share another win. We've got a few more that we're going to be sharing. Most of them we've never shared. We just keep it all inside because it's a nice private group. Very friendly, supportive, very friendly. And that's how we keep it: positive, friendly, and that's the way it is. Anybody that's negative, then we have to leave immediately. Go and check it out. I will put the link in the description. Get along there and have a look. And then we'll see you later.